Lloyd, Respondent, and Google, LLC, Appellant.
Lord Leggett will summarise the Court's judgment.
The question raised by this appeal is whether the claimant, Mr. Richard Lloyd, who is backed by a commercial litigation funder, can bring a claim against Google LLC in a representative capacity, seeking compensation for damage allegedly caused to a large number of people through breaches of data protection law. The factual allegation made is that for several months in late 2011 and early 2012, Google secretly tracked the internet activity of some 4 million Apple iPhone users in England and Wales without their knowledge or consent, and used the data collected for commercial purposes by enabling advertisers to target advertisements at users based on their browsing history. Mr. Lloyd claims to represent all the affected Apple iPhone users. His claim to recover compensation is made under the Data Protection Act 1998, which was in force at the relevant time, although it's since been replaced by the General Data Protection Regulation, supplemented by the Data Protection Act 2018. Class actions in which a single person can claim compensation for harm done to a class of people have long been possible in the United States, and more recently in Canada and Australia. In the United Kingdom, they are now possible under legislation enacted in the field of competition law. But no such legislation has been enacted for other sectors, such as data protection. To overcome this difficulty, Mr. Lloyd seeks to rely on a procedure of very long standing in England and Wales, which allows a claim to be brought by or against one or more persons as representatives of others who have, quote, the same interest in the claim. This representative procedure is contained in Rule 19.6 of the Civil Procedure Rules applicable in the High Court. Mr. Lloyd accepts that he cannot use this representative procedure to recover damages if the amount of compensation payable to each person whom he seeks to represent has to be assessed individually. But he argues that such individual assessment is unnecessary and that he can use the representative procedure to claim a uniform sum of damages for each person whose data protection rights have allegedly been infringed, without having to prove any facts particular to that person. A sum of £750 per person has been suggested in correspondence. Multiplied by the number of people whom Mr. Lloyd claims to represent, this would produce an award of damages of the order of £3 billion. Because Google is a Delaware corporation, Mr. Lloyd needs the court's permission to serve the claim form on Google outside the jurisdiction. Google has opposed the application on two grounds. First, Google contends that under the Data Protection Act 1998, compensation can only be awarded for financial damage or mental distress which an individual is shown to have suffered as a result of a contravention of the Act. Second, Google argues that the present claim is in any event not suitable to proceed as a representative claim. In the High Court, the judge decided both issues in Google's favour and therefore refused permission to serve proceedings on Google. The Court of Appeal reversed that decision. Google now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal and restores the order made by the judge. I give the sole judgment with which the President of the Court, Lord Reid, Lady Arden, Lord Sales and Lord Burrows agree. In my judgment, I examine the history and scope of the representative procedure and emphasise that, as described in the case law, it is a, quote, flexible tool of convenience in the administration of justice. This view of the representative procedure has also been adopted by the highest courts of Australia, Canada and New Zealand. It is all the more appropriate in the light of modern developments, such as digital technologies, which have greatly increased the potential for mass harm for which legal redress may be sought. I explain that it's not a bar to making a representative claim that each represented person has in law a separate cause of action, nor that the remedy sought is or includes an award of damages. Damages may be claimed in a representative action if they can be calculated on a basis common to all the persons represented. Alternatively, issues of liability may be decided by a representative claim, which can then form the basis for making individual claims for compensation. In the present case, a representative claim could have been brought to establish whether Google was in breach of the 1998 Act as a basis for then pursuing individual claims for compensation. However, Mr. Lloyd has not proposed such a two-stage process. That is doubtless because pursuing individual claims for compensation would not be cost-effective. Instead, as I've mentioned, Mr. Lloyd maintains that individual assessment of compensation can be avoided. In particular, he argues that a uniform sum of damages can be awarded to each member of the represented class under the 1998 Act for, quote, loss of control of personal data constituted by any non-trivial contravention by a data controller of any of the requirements of the Act. For the detailed reasons given in the judgment, I reject these arguments and conclude that the claim cannot succeed, essentially for two reasons. First, the claim is made under Section 13 of the Act, which states that, quote, an individual who suffers damage by reason of any contravention by a data controller of any of the requirements of this Act is entitled to compensation from the data controller for that damage. Compensation cannot be awarded under Section 13 for a contravention of the Act, however serious, in and of itself, but only where it's established that an individual has suffered damage as a result of such a contravention by a data controller. On a proper interpretation, the term damage refers to material damage such as financial loss or mental distress, which is distinct from and has been caused by a contravention of the Act. Second, in order to assess what compensation, if any, an individual is entitled to receive under Section 13, it would in any case be necessary to consider matters such as over what period of time did Google track the individual's internet browsing history? What quantity of data was unlawfully processed? Was any of the information unlawfully processed of a sensitive or private nature? What use did Google make of the information? And what commercial benefit, if any, did Google obtain from such use? In the absence of any evidence about any of these matters, an individual is not entitled to recover compensation. The attempt to recover compensation without proving any facts particular to any individual iPhone user, and in particular without alleging or proving that Google's alleged unlawful conduct caused any financial damage or mental distress to any such individual, is therefore unsustainable. In these circumstances, the claim cannot succeed, and permission to serve the proceedings on Google outside the jurisdiction was rightly refused by the judge.